This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why it can be criminal to falsely claim to be an insurer and why it is necessary to allege sufficient evidence before bringing a suit for business disparagement or a business type of defamation. It's just not nice to claim that your competitor is not an insurer and you are when neither party is truly an insurer. Plaintiff Route App, Inc. moved the United States District Court to dismiss two counterclaims asserted by OrderProtection, Inc. OrderProtection in Route App, Inc. versus OrderProtection.com, Inc. Julian Wilson et al. The United States District Court for the District of Utah on December 9, 2024, found no evidence supporting a claim of business disparagement or business defamation. The case involved a dispute between Route, a post-purchase shipping insurance provider, and a competitor, OrderProtection. In its complaint, Route alleges that OrderProtection and several of Route's former employees misappropriated trade secrets to create a competing business, and in response to Route's complaint, OrderProtection filed an Answer and Counterclaims, asserting 4 causes of action: 1, unfair competition in violation of the Lanham Act; 2, defamation per se, defamation, business disparagement; 3, tortious interference with existing and prospective economic relations; and 4, negligent misrepresentation. The facts pertaining to OrderProtection's claim for defamation, defamation per se, and business disparagement are essentially that Route employees have allegedly told OrderProtection customers and potential customers that they should work with Route instead of OrderProtection because Route is a legal insurance provider and OrderProtection is not. OrderProtection argued that Route is not a licensed insurance company and that at best Route affiliates with an insurance producer to procure its own insurance coverage, which does not benefit customers or merchants. More importantly, both Route and OrderProtection, in essence, both self-fund the warranty protection they provide, and thus a customer is no better off with Route's protection package than with OrderProtection's non-competitive offering. Specifically, while OrderProtection's opposition memorandum does not explicitly state that it conceded its defamation and defamation per se claims, OrderProtection never addresses Route's argument that it could not properly maintain these causes of action in the context of this case, and even if OrderProtection had not conceded these claims, it failed to establish that these claims were viable in the context of this case. Further, OrderProtection made no argument that the Utah law recognized a hybrid cause of action for defamation per se, wherein a business disparagement claim may be analyzed using defamation or defamation per se case law rather than the case law pertaining to a business disparagement claim. The parties agreed that to state a claim for business disparagement, sometimes called injurious falsehood, OrderProtection must allege 1, falsity of the statement made; 2, malice by the party making the statement; and 3, special damages. According to Route, while OrderProtection has made allegations of lost customers, it has not named specific individuals, nor has it alleged with particularity any financial losses, which is required under Rule 9 of the Federal Rules of Civil Procedure. The court declined to recognize a business disparagement per se cause of action in which special damages need not be alleged, and it declined to recognize a business disparagement claim that relies on a statement that is false by implication, which is a concept that has been recognized in defamation cases. Route's motion to dismiss was granted, and OrderProtection's claims for defamation and defamation per se were dismissed with prejudice. Its claim for business disparagement was dismissed without prejudice, and OrderProtection was allowed to file a motion for leave to amend by January 10, 2025, if it is able to allege a proper business disparagement claim as discussed above. In my opinion, two businesses claiming to be insurers of insurance who are not licensed insurers claim to be victims of disparagement by the other. Customers, because of the various claims, shifted from one party to the other, but contrary to their claims, were self-funding what they alleged was insurance of shipments of goods, and the court, in a Solomon-like decision, ignored the fact that both claimed to be insurers when they were not, and used the false claims to take over clients. Both lost, and the court gave OrderProtection the attempt to state a business disparagement claim, implying that the court did not believe OrderProtection would be able to plead a viable cause of action. In my opinion, also, the state of Utah Department of Insurance should consider this case and these two parties claiming to be insurers when in fact they are not. This video was adapted from my blog, Zalma on Insurance, and is available to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5 or 6 a week, and you'll gain access to the more than 4,950 blog postings. Please tell your friends and colleagues about this blog so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.